Good morning, and thank you for joining this morning's NJ Car webinar, focusing on helping dealers learn how to best navigate the complexities of online sales in a world of stay-at-home orders, showroom shutdowns, and social distancing. Today's presenters include Brad Miller from NADA, Michael McMahan of Arent Fox, Perry Pittenger of Schiller, Pittenger, and Galvin, as well as Jim Appleton and Anastasio from NJ Car. I believe Brad and Michael will be recapping issues that impact every dealership, while Jim, Anthony, and Perry will focus primarily on New Jersey-specific issues. Before we begin, I just have a few quick housekeeping details. On the right-hand side of your screen is a control panel. I'd like to primarily point out the audio tab, which has your call-in information, and the questions tab in particular. During the call, all participants will be muted. We expect there will be a lot of questions, but if you have a question during the presentation, we ask that you write it down. We'll give you a heads up when the webinar is winding down, and you can submit your question in the questions tab if it hasn't already been answered. Now I'd like to turn things over to Jim Appleton for a quick update before Anthony kicks off today's webinar. Jim?
Yeah, good morning, everyone. First and foremost, a big thank you to our presenters, Brad Miller, Mike McMahan, and Perry Pittenger, on behalf of NJ Car and all the dealers who are on this call. I want to thank you for lending your time and expertise to help dealers better navigate and understand the rules of the road as we move forward with greater emphasis on online sales. Let me just take a brief detour to talk a little bit about where we are here in the state of New Jersey. As I think everybody knows, we have an executive order that requires all sales activities to be carried out remotely or online, and requires that deliveries be made either in the service lane, curbside at the dealership, or at a consumer's home. Obviously, this is a whole new arrangement that carries with it a significant number of legal perils that we want to make sure everybody on this call is familiar with. Some good news. Earlier this week, we received notice from the governor's office, and the team here will go into more detail on it, that test drives under very strict conditions would be permitted. That's a piece of what we had asked for. NJ Car has been lobbying the governor's office over the last week and a half to allow by appointment sales at the showroom. We've made the case to the state that they're losing at current sales volumes $4.5 million a day in sales tax and motor vehicle fee revenue. And while I don't think any of us think we can get back to 100% sales simply by opening up showrooms to by appointment, we do think, A, we could open up by appointment in the showrooms safely. And secondly, we think that there is pent-up demand that could better be served if we opened up the showrooms. That would, of course, help dealer sales, dealer revenues, but just as importantly, would help the state. So with that brief update on the status of where we are now in New Jersey, let me once again thank our panelists for their participation. And also let me offer the caveat that while this webinar is meant to provide you with information and the tools you need to better identify the rules of the road going forward, it is not legal advice. And if you have specific questions about your operations and whether or not a particular strategy that you wish to employ is legal or not, you're going to need to consult with your own legal counsel on that. So with that, let me turn it over to Anthony Anastasio to walk us through the program.
Thank you, Jim. Today we're going to go through some of the issues that this online sales paradigm that's been thrust upon us as a result of COVID-19 the things that we have to think about and the issues we need to confront in putting our plan together to try to compete in this environment and remain profitable to the extent possible. First, we're going to go through the background of online marketing and sales in New Jersey. Then we will pivot to the executive orders, administrative orders related to COVID-19 that have allowed for a change in the state's approach to online sales. And then we'll go through some federal and state laws that govern online sales and that apply to regular in-person sales, but also extend to the digital online or remote sales process. So with that, I'm going to go into some of the background. It's been NJ Carr's understanding for quite some time that, due to the Motor Vehicle Commission's regulations and Title 39, that dealers were prohibited from engaging in sales activity over the internet. So what do I mean by sales activity over the internet? We're not talking about online marketing. I mean, everybody has a website with their advertised prices and vehicles. We're not talking about communications with customers over email or through web portals. That's been fine, and the MVC has no issue with it. What we're really talking about is the final negotiations and execution of sales and lease agreements. All that stuff, the latter, the negotiations and the execution of contracts, has to be completed at the dealer's licensed location. Typically, that's at the dealership. Off-site delivery, however, has been permissible. They'd have no problem with that, but that can only occur after the paperwork is signed, after the deal is complete. It's a ministerial act. You're not selling when you're delivering. You're simply just driving the car or flatbedding the car to a customer's home. There's a lot of confusion about these requirements because, quite frankly, dealers' compliance with them and the MVC's enforcement of these requirements is very inconsistent. Throughout, the outset of this pandemic, we were constantly getting questions about, well, are online sales permissible? Are they not permissible? And until, the state clarified it in its administrative order allowing it, our answer was, based on the regulations and the statutes on the books, the answer is no. Sales activity over the internet is prohibited. But there are some players out there that seem to get a pass. And we've been kind of playing tug of war with the NBC, over Tesla, over some other, disruptors, new entries into the marketplace who are designing their business model on a more online-oriented sales process. But as a result of COVID-19, it looks like the issue is, at least for the time being, resolved because the governor's office has elected to permit it. So initially that wasn't the case. They first, in response to COVID-19, issued Executive Order 107. Basically, this was on March 21st, non-essential brick and mortar retail was shut down due to the pandemic. Car dealers were considered essential retail, but could only operate their service departments. Showrooms were closed to the public. The order did not say anything about online sales for dealers specifically. It did say that online sales were permissible if allowed under existing law, which forced us to go to the MVC regulations and the Title 39 statute, and we determined again they're prohibited. So the order did allow for the service department to remain open, and that was the first few weeks of the pandemic, or first week of the pandemic, what we were focused on in giving kind of compliance guidance, and then we lobbied on the back end to allow online sales. So on March 30th, about a week after the first order, Governor Murphy issued Administrative Order 2020-6 in response to our lobbying efforts and allowed what he called contactless motor vehicle sales during the press conference, which released the order. And the only language in that order that really related to this relaxation of pre-existing law and regulation regarding online sales was what is on this slide. And there was two sentences that really govern the process. There really wasn't much. The first one, car dealers may continue to conduct online sales or remote sales that can be completed by phone, text, or email and are consistent with current law. And then the next part, the car may be delivered to the purchaser, and the purchaser can pick up the car curbside or in the dealership service lane. So that's all we had at the outset when Governor Murphy agreed to allow online or remote sales. It doesn't really give much guidance on how this stuff's supposed to occur. And of course, it begs the question, what do these things mean? Consistent with current law. I mean, the way we read that, we believe it suggests that these contactless sales had to follow all of the same rules that apply to in-person sales to the extent that they weren't modified by the administrative order. And we'll get into some of those pre-existing laws in a minute. The next, I think, key term, which was unclear, was curbside. What does that mean? I think it's clear that the customer certainly cannot enter the showroom to take delivery. The questions I was getting, how about an outdoor canopy or a tent with a desk? How long, can we interact with them? How should these interactions occur? Again, we didn't have any answers to those questions at the time. Our attitude was, until we get more clarification from the governor's office, look at the CDC guidelines, the OSHA guidelines, speak with your attorney, try to formulate a plan that makes sense under the circumstances. It's very fraught with liability given the fact that we're in in a pandemic, and there's really not a lot of guidance from the governor's office on how this stuff is supposed to occur. So, really it forced us to think about what are the current laws that really apply here, and how can we use them to formulate some framework for how this stuff's supposed to happen. We didn't really, typically legislative or regulatory, enactment or promulgation will involve a lot of back and forth between legislators and NJCAR or other interest groups. Likewise between regulators and NJCAR, and we really have a lot of time to think about the issues and work through them with whoever's drafting the language, so that when the time comes that these things go into effect, we know where everybody stands and they have time to get up and running with compliance. That wasn't the case here. I mean, it was done in a matter of days. We got this go ahead for online sales, and it was just, well, how do we do it? We just had no roadmap because it never been allowed before. So it forced us to really look at a lot of the pre-existing laws that still applied to really kind of formulate a way to do this stuff without creating problems down the line once the dust settles with the pandemic, where we're going to end up with a bunch of lawsuits. So we've got a few federal laws that Brad Miller and Mike McMahan are going to go through, and then we'll go through state laws that I think are relevant. Namely the remaining executive administrative orders that the governor issued after Executive Order 107 and Administrative Order 2020-6, the pre-existing New Jersey Motor Vehicle Commission dealer licensing laws, New Jersey's Uniform Electronic Transactions Act, some issues with the New Jersey Motor Vehicle Commission's wet signature requirements and how they interplay with this online and contactless sales process. And then finally, we're going to get into some of the New Jersey advertising regulations. Perry and I will discuss how those apply in this context. So I'm going to turn it over to Brad and Mike to go through some of the federal requirements. Does anyone have anything to add regarding those executive orders that I just attempted to parse before we move forward? Perry, Mike, or Brad, anything that you'd like to add?
No, I think you put it exactly the way it is.
Okay,
yeah,
great.
I would just reiterate that this is, this crisis is not a free pass to ignore all the pre-existing compliance that you've been doing for years. As we're going to go through this slide, there's still a lot of things you have to try to comply with as you navigate this. You can't just, it's not a free-for-all.
Yeah, on that point, Mike, I'd also add that, if something goes sideways, somebody, doesn't follow the rules, the optics are just terrible. If there's any indication that dealer was trying to exploit the environment and laxed enforcement, to their personal gain, it's just really will look bad for the dealership. So I think, the compliance, the burden is higher and the stakes are higher, and I think the consequences are greater if anybody believes that a dealer was exploiting the situation, and lack of enforcement for their own gain. With that being said, I'm going to turn it over to Brad and Mike on this these federal issues. Thanks, guys.
Well, thanks, Anthony. This is Brad Miller, and I should preface all this. First of all, thank you for having me. But I should preface all this by saying there's just way too much here to cover in any detail in just this 1 hour. We want to give a lot of focus to the state, New Jersey specific stuff. But there are additional resources on the NADA Coronavirus Hub. We've got a couple webinars just on these topics, including, as I'm sitting here listening to Anthony's explanation. We did a whole webinar that took over an hour and a half just the other day on what is an online sale and the types of vendors you may need to engage. And we're not going to even have time today to talk about federal e-sign requirements. There are issues under the Federal Truth in Lending Act and Reg Z that you have to be careful about. So we wanted to touch on at least a few issues that are sort of potential pitfalls that you may not think of from a federal perspective, but there's more that we'll be able to touch on today. So with that said, let me just very briefly touch on a couple developments in the marketing space. And it struck us that, of course, as fewer folks come into the showroom, there are going to be a lot more remote interaction with your customers, including by text messaging. And hopefully you all know already that text messaging has got a lot of risk associated with it under federal law, under a statute called the Telephone Consumer Protection Act, or the TCPA. It's frankly been an area of lawsuit abuse over the last few years. It's got statutory damages and a very aggressive enforcement and plaintiff's bar perspective on this. So we just want to remind you that, especially if you've got employees working from home, communicating with customers on their own personal phones, maybe outside your normal compliance structure that you've got set up in the store, that you should exercise particular caution with respect to text messages. I also note, while the Third Circuit in New Jersey has got a positive case, Mike tells me, and Mike can go into that, there has been a recent bad case in the Second Circuit on the TCPA on just the underlying issue about liability for text messages. So Mike, that was a very quick overview of this. We're going to touch on one other specific issue, but before I go to the next slide, anything else to add, Mike?
Yeah, I can just talk a little bit about the case split, and this is something that might be surprising to some of you, but some of these circuits, Second Circuit covers New York, Ninth Circuit covers California. They've basically held that even if you have gotten a customer at some point to opt in to receiving text messages, you got their phone number, if you use an automated computer system to text them, you can be liable under the TCPA, which is kind of a shocking result from what I think normal business practices have been and the normal understanding has been. Thankfully, the Third Circuit, where New Jersey is, comes out the other way. If it was a manually inputted number, if it wasn't randomly generated by a computer just dialing all the numbers there are, then it doesn't result in liability. But this circuit split is certainly going to set up something in the Supreme Court, and they're going to have to come down on this one way or the other. So this is still, I would think, very unsettled at the moment.
Yeah, this is just, I'm editorializing here, but this has been an area where the plaintiff's bar these cases have gone through the roof, these class action demands. I'm sure you've seen them. So again, this is a reminder. It's not necessarily the last bullet I will say, we'll mention this sometimes. Obviously, any COVID-related marketing, you have to be very careful.
Brad, I think we're losing you. Are you there? Oh, man.
Did Brad bail?
I think he was saying he was having storm problems. Maybe we can have him dial back.
Next slide.
Oh, okay. Brad, you're there. Is everybody there?
Jim's here.
Brad Miller?
Yeah, Brad, you're cutting in and out pretty badly. I don't know if you can try to dial in.
Let me try something here. Yeah, let me try one thing. Let's see if this helps. Sorry about that. I'll dial in is that better?
Yes, much better.
Much better.
All right, sorry about that. Okay, let me know if that happens again. I'll dial in on the phone. So very quickly,
We're losing you again.
All right, I'm going to call in on the phone. Mike, if you want to try to handle this, I don't know if you know what this is about, but I'll call in.
Yeah, I'll do my level best, and then if once Brad gets back on, he can fill in any details. Essentially, there is an emergency exception to the guidance about auto dialing and auto texters, but typically that exception is for actual emergencies, which is a hospital, a healthcare provider, a state and local official, your local government saying alert. Lockdown in place, quarantine, health hazard, or recently, apparently, the city of Hoboken still believes I live there, and I got a phone call about a water main break. That's the kind of stuff that this is talking about. Informational content, PSA type things, it is not going to apply to you trying to sell somebody a car. Like, it's just that is not going to get you out of any TCP liability you might otherwise have. Yep.
Yep, Brad, you're back. You're clear now. We can hear you.
Awesome. Sorry about that, everybody.
No,
I will just add to what
Mike said that we get a lot of questions from dealers on.
Brad, I'm sorry to cut you off. You got a lot of feedback. If you could turn your speaker off on your computer, it probably will fix it.
Okay.
Sorry about that.
No, I apologize.
Is that better?
Still getting a little bit of a delay.
I think it's his mic is still on his computer.
Okay, that's probably the other. Yep.
Well, if I can figure out how to.
Brian, can you mute? Can you mute Brad on his?
No, that'll mute the phone. Brad, I think you're okay now.
How about that? There we go. I figured out how to do it.
Yeah. Right. Yep.
All right. Whew. All right, guys. Sorry about that, everybody. Yeah, look, I'll just add to what Mike said that essentially we get a lot of calls from dealers saying, what about things like safety recalls? Can I send a text? Isn't it a safety emergency that the car is subject to an open recall? And there was a little bit of an open question about that. The FCC on March 26th, you can see here. Hopefully this is a link to this document if you want it. If not, I can get you one. But the FCC issued a declaratory ruling just last month and said no, basically. I mean, you can see what they say here is that it's okay for a hospital or a local or health government official to send a text, but it's not going to be okay for you to send a text message under this exemption about recalls, about what steps you're taking for COVID, about your hours of operation, whatever it may be. So, again, it's just a question we tend to get a lot, and we finally did get a little bit of guidance from the FCC on this. Obviously, just like everything else we've said, this is an area where you don't want to be using the COVID issue as an excuse for sending text messages that you wouldn't otherwise have done. So sorry for my technical issues, but we can go to the next slide if you want to, unless Mike, if you want to add anything further.
No, I think that covers it.
Okay. Well, that's text messaging. Wish we could spend an hour just on that, but in the interest of time, very quickly. To me, the other big issue that I think when you're doing online sales that you really have to think about, and there is a federal law overlay on this, but the basic issue is identity theft. And I've given you some links here to what the federal government is saying, but we're getting a lot of reports from both federal law enforcement and regulatory agencies that scams are massively on the increase, that the bad situations like this bring out the worst in the bad guys. And there's been a huge increase in fraud efforts in all sorts of ways. Vehicle financing has always been a place where there's been a lot of fraud efforts undertaken. Organized crime has very, very advanced efforts in this area. I've seen all sorts of interesting things. I've seen folks recently reports of folks who have tried to clone VIN numbers off of a rental car, for example. So they send pictures of their purported trade-in for an online sale and clone the VIN from a rental car and try to pass that off as the vehicle that they're selling. So people are very creative. You got to think about ways that your current processes are going to account for this kind of identity theft. And frankly, you may want to think about what you're telling your customers just to ensure them, hey, we'll never ask you for this kind of information via email or over the phone. If you get one of these calls, let us know, that kind of a thing, because both you and the customer are at risk. We've heard a lot of folks trying to scam businesses like dealers on PPP loans, all sorts of things that you just have to be aware of. And Anthony, next slide, this is the tie into federal law, is remember, you've got a duty under federal law under what's called the red flags rule to take steps to confirm the identity of someone who is applying for credit to purchase a vehicle. So it's called what's called a covered account. We've got a guide that's very long and detailed. If you want the details on this, you can get it on our website. But the bottom line of all this is you take steps today to verify the identity of the people that purchase vehicles from you. And the question is, what are you going to do in a remote delivery online sales situation? You can see this is from our guide from 10 years ago. We note that even if you deliver the car offline, you still have an obligation. Even in an e-contracting environment, I've talked to the e-contracting vendors and lending sources who take e-contracts. They're not saying that somehow absolves you of the responsibility to confirm identity. In fact, they're putting more of an onus on you as a dealer to do this. So what are you going to do? And there are some steps you can take, but you got to think about it now. I mean, think about a situation where you, as a practical matter today, one of the things you hopefully do is you compare the picture on the person's driver's license to the person sitting across the table from you, right? You may even check the signature on the back of the driver's license and compare it to the credit application. Well, they're not there signing a credit application. They're not there sitting across the table from you. When you deliver the vehicle to them, they may be wearing a mask, or they may, it may be someone coming out and saying, well, my grandmother is buying the car, but she doesn't feel comfortable coming out. So you're going to have a lot of situations you're going to have to deal with. And again, you got to think about this beforehand. You got to think about what steps you're going to take in a remote or an online delivery, or online sale or remote delivery, to make sure that if someone says they're Brad Miller coming to finance a vehicle through you, that it's actually Brad Miller. So Mike, I don't know if you want to, I went through that very quickly, but if you want to jump in with any thoughts.
But the other thoughts is that beyond just the federal law, it's almost entirely likely that your master services agreement with your lender or captive finance arm has very stringent requirements that you verify the identity of any person that you're trying to put through their system, and there could be consequences if you don't, such as you're going to be on the hook for the loss if it's an identity theft and you didn't take the steps you needed to take to make sure that reasonable steps to make sure it's the right person. Now, if they're some sort of master crook that has fake IDs and false forms and you did everything you were supposed to, that's a different story. But you can't cut corners just because of the crisis.
So go to the next slide, Anthony. Yeah, look, it's exactly right. I mean, generally speaking, this makes these recourse loans, and you're going to be eating the loss. We don't want a whole bunch of dealers in 60 and 90 days facing this issue because they were so anxious to sort of work in this new environment, they didn't take the steps they needed. So what can you do? As Mike said, I would start talking to your finance sources now just to make sure that you've talked to them about the new normal. See if there's any tools they have that they can provide you with. I've heard of some folks who say things like, maybe that they have some alternative. The finance source has some sort of alternative ID verification that they can work with dealers on, where there's out-of-wallet questions. That first bullet, out-of-wallet questions just means questions that you ask someone that only someone, who is Brad Miller would know. Now, that's its whole other issue. That's its whole own issue. If you start asking people very tough questions about, their mortgage balance and they don't know the answer, you're going to have to figure out whether that's really just because they're an identity thief or they just don't know. So this creates a lot of issues. I will say, you could do a virtual review of things like a driver's license. I know in some states, I don't know if New Jersey is one, in some states they allow you to sort of scan the barcode to get information. Maybe you could do that remotely. But even doing that creates additional issues because, of course, you've got to worry about the security of that information and caution about where you send information. So that's a big issue that we're just going to touch on very quickly in the interest of time. But Mike, if you don't have anything to add to that, we can move to the next one.
Sure.
Next slide.
Yes, please.
Okay.
So that ties into this issue again. We could spend a heck of a lot of time just talking about this. Just remember, you still have a federal obligation, an obligation under federal law to safeguard the data that you get from your customers. Now, we could spend some time explaining what non-public personal information is and what isn't. Let me tell you that in my personal view, and that's not just my personal view, I think it's the FTC's view, if you've got information that could identify a person or inconvenience or embarrass them in any way, then you better be protecting that at the highest level. And if you're adopting new policies and procedures, if you're doing video chats to do an F&I presentation, you better make sure that that system you're using meets the requirements under your safeguards obligations, because you're getting very sensitive information from consumers using maybe new systems, new processes, and you just have to make sure you've gone through the hoops that you have to go through to make sure this stuff is secure. I will tell you that the link at the bottom, one thing that you may do, like I said, we did a video or a webinar just the other day on to do a remote e-contracted, e-signed deal, which you may or may not be doing, may require you to engage new vendors and new third parties. You have to make sure those folks have certain contract provisions in the contract. At that link, we have a service provider contract template that we've actually provided. It's been out there for a few years. It's the very basics. If I was your lawyer, there'd be a couple other things I would make sure we're in those agreements. But just don't forget this stuff, because in the rush to do these things and the rush to do something new, we just want to make sure that you understand that anywhere that the information is touched or stored has to be secure. I mean, for example, you should never send any sensitive information via email, because it's generally considered to be insecure. So if you're going to be doing that remotely, which it sounds like under your executive order you can, you better make sure you've got a secure document handling system in place. So, Mike, I know you probably have a lot to add there, but that's just sort of an overview from the federal perspective of what you have to do.
Yeah, I would just reiterate that you don't want to be using an AOL.com email for this. You don't want to be, sending people's personal information over text messages, which is just not a secure platform. You want some sort of encrypted method that secures these people's data and privacy, because if you think the TCPA plaintiff's bar is annoying, just wait till you see the privacy bar. There are a lot of issues that are raised out of the collection of this PII, and that even extends to what services you're using for video calls. If you're doing an F&I presentation over a video call, it better be secure. Zoom has had some issues that have come up as of late, and not entirely sure who can intercept it, but you don't want it that you collect the person's information in a video call that some hacker was able to easily get access to. That's not saying you're going to be able to provide, triple secured FBI level encryption for your customers, but you at least need to take reasonable steps so that you have an argument that you acted in good faith and you did what you were supposed to do.
Absolutely. So again, this is a complicated issue that we're trying to summarize quickly, but the other bucket that we haven't talked about is, to the extent you have employees that are working remotely, that raises a whole panoply of issues as well. Obviously, you don't want them calling or texting from their personal phones, because that's all outside of your do not call and your TCPA compliance framework that you've got. How do you know that if somebody's opted out, if they're talking to someone on their personal phone? Not to mention the technical issues that come from employees accessing software packages remotely. So anyway, it's a lot to think about, but we don't want folks to get blindsided with this and have trouble a few months down the line. Next slide. All right, so very quickly, one last issue from a federal perspective that we wanted to share with you, because this is sort of the classic gotcha here in my view, which is you inadvertently run afoul of a federal prohibition without really realizing it. So there has been for almost 50 years a rule under federal law called the cooling off rule, which basically says that if you engage in door-to-door sales, then you have to provide a certain notice to that consumer, and if that consumer, if the sale was solicited or consummated at the person's home, then they get a 3-day right of rescission. for the sale. Obviously, in the car sales environment, that would be problematic. Now, nothing saying you can't give people a 3-day right of rescission on your own. You can control that in any way you want. But this is one of those areas where historically we've not had a problem for sort of highly technical reasons I could get into. But the issue that has arisen is with showrooms closed to the public, arguably this rule could come into play. So what can you do? Next slide, Anthony. We have some guidance from the FTC on this. Now, this is, as you can see, again, this is a link to this document, which you probably can't read, but it's from 2001, and you see the quote there that I think is the key quote, which says that if all you're doing in the course of delivering a vehicle to someone's home is obtaining signatures from the consumer at their home for a previously negotiated transaction, you don't trigger the cooling off rule. Now, this is informal staff guidance from almost 20 years ago, but we have no reason to believe that it's not still accurate. And the point of that is what you can do under federal law without triggering the cooling off rule is deliver the vehicle and even obtain signatures at the consumer's home. Now, I know, Anthony, I'm sure we'll talk a little bit about whatever wet signature requirements are still required under New Jersey law, But you know, you've got federal e-sign. You theoretically could get the signatures online if you've got the processes in place to do it. But if you don't, you can still, you know, with social distancing and all the rest of it, single-use pens and everything else, you can still get the consumer's signature on the sales documents at their home without triggering this rule, as long as you don't negotiate any part of the transaction at their home. So next slide, very quickly. What does this mean? If you just get the signature, you're probably okay, but it certainly also makes it, if it doesn't make it clear, but it certainly implies, and I think it's true, that if you do negotiate any part of the transaction at the consumer's home, you could implicate this rule, and you could be inadvertently triggering a 3-day right of rescission. So what does that mean? That means you need to have a firm trade-in number before you get to the person's door. You can't have everything negotiated except the trade, get there, review the trade, and give them the number when you get there. You can't make F&I presentations at the person's home. You can't, you know, do anything that would change the terms of a previously negotiated transaction from a federal perspective without the risk of triggering this rule. So again, this is just one of those areas where it's sort of this very hidden area of federal law that wasn't a concern for dealers for many years. But now, because of the fact that your showrooms are closed and you're doing these deliveries at home, and it's both those pieces together that make this an issue, you've got a risk here. And so, Mike, I'll let you, obviously, you jump in at any time, but one thought, and again, I don't know the state implications of this, so I want to be careful. Anthony or Perry, if you want to jump in. One thought that I've heard is a suggestion that you ensure that you don't have, have any salespeople involved in the delivery of the vehicle. That way you're creating a record that you're not engaged in sales. Now, I don't know if that creates issues. You're going to talk about that later. Okay.
Yeah, for dealer licensing reasons, it's in New Jersey, you know, it's kind of connects with this in that, you know, we don't want to stray too far from the dealer licensing regime that previously existed before this administrative order that allowed online sales. So to the extent that, you know, sales activity can be done from the dealership by a salesperson there, you know, we think it's the conservative approach is to continue doing so. And that hooks directly into this cooling off issue that you're raising here. And I think you're absolutely correct. The salesperson should probably not be the one delivering. It should be a ministerial act by a delivery person, basically, who's trained how to do it safely.
Yeah, the bottom line is that if there's any upselling at the end, if you're trying to sell a tire warranty, if you're trying to sell something that was not already agreed to at the time you deliver, you've just turned their home into a site of a sale, and you basically become a vacuum salesman, like at that point, and you don't want to run that risk.
That's correct.
Yeah, you could. And I'll just note also, technically speaking, this is true if you delivered anywhere other than your dealership. So let's say they say, well, I don't want it in my driveway, but please meet me around the corner in the church parking lot because I don't want a salesperson at my home. Right. It still applies. Now, curbside, which I think I heard earlier, it's an interesting question. I think curbside, whatever that means, you're probably not triggering this in my view, but that's sort of a best guess because who knows what curbside means, as Anthony said. But anywhere away from the dealership, you could trigger this rule.
Yeah, exactly.
Okay.
Anywhere but the dealership, it could be a problem.
So yeah, Mike, feel free to add in, but from a federal perspective, we just wanted to hit on a couple of those areas that are sort of, these are gotchas, trigger, we don't want you to inadvertently run afoul of something you weren't aware of. We wanted to highlight a few of these, but please, take a look at some of the other NADA materials. You'll get a lot more on other issues like e-sign and TILA and some of the other federal things that you need to consider as you do this going forward. So thank you very much.
For the audience, thanks, Brad. The NADA materials and the webinars that they've conducted are fantastic. They're available on NADA's website for free for members. We just wanted to quickly go over some of the highlights in this webinar for our members who haven't had a chance to review the NADA materials, but I really recommend to everyone on the call who's participating and who's listening to review the NADA stuff. It's just fantastic, and I can't recommend it enough. And it really gets into more detail about these federal issues. And we just wanted to leave some room in this webinar for the state-specific stuff. That was the idea of this. So again, thank you, Brad and Mike, and I hope that to the extent you have anything to add on the state side as we barrel into that, feel free. Just let me know. I'm going to take over now. Perry and I are going to go through the remaining executive orders that have gone into effect after the initial executive orders 107, which declared essential and not essential retail, and then administrative order 2020-6, which allowed online sales. There are two subsequent orders which are highly relevant to online sales, the first of which is executive order 122. Now, this was issued on April 8th. And I think the idea was, as the pandemic was really ramping up at that time, the governor, I think, realized that it was incumbent upon his administration to really give a specific roadmap for essential businesses that were continuing to operate, and then also essential retail businesses, and also manufacturing and office spaces. What they did was they basically took the CDC's and the OSHA's guidance and requirements regarding operation of businesses and during the pandemic and maintaining workplace safety, and they put them in an executive order in a way that kind of culminated all in one place, that easy to understand. And this applies to us for the service department, which is still open. The brick and mortar service departments for dealerships are still open as essential retail, but also to the extent that there's any type of in-person or interactions with customers on remote or online sales. I think this order is your guide. I mean, ultimately, the remote and online sales, there's going to be some interaction. There's going to be some, direction given. There has to be some confirmation of delivery. There has to be some, I think, confirmation that the person who's picking it up is the person who bought it. Some identification has to occur. And then also, when you're delivering it to someone's home, you want to confirm that they get it. You're not going to just leave the keys in a car and drive away. So I think this is your roadmap. In addition to the CDC's and OSHA's guidance, this incorporates most of it, if not all of it. And this is really what you need to look to figure out. All right, how am I going to get a wet signature on an motor vehicle commission document like a power of attorney, or how am I going to get a wet signature from somebody who doesn't have the internet, who completed the whole transaction over the phone, and has to just sign the contracts on site. How am I going to do that stuff? This is your guide. So what we tried to do is we look through Executive Order 122 and try to find. I mean, it's not geared directly to online transactions, but we try to look at it and say, okay, what parts of this really are relevant for purposes of structuring an online kind of sale process, where when you have to interact with people, and how do you do it? And by no means is this exhaustive, and by no means is this the definitive guide, end all be all. And I'm going to say, I'll say it now, I'll say it again. As you formulate these policies, they should be in writing, number one, so that everybody can receive them, confirm receipt, indicate, they acknowledge they understand them, and that you have a record that you created policies and distributed them. But also, those policies, as they're formulated, should be done with its assistance, or at least the blessing of counsel. You could do it yourself and get counsel to review it, or you could do it with them, because the liabilities here are pretty substantial. We're talking about selling cars during a viral pandemic. And we're living in this now, and it's kind of still I think a lot of people are in disbelief about it. But if you step back and you really think about it, this is unprecedented. And when this, if and when this blows over, and the dust settles, you can be guaranteed that the lawyers are going to come out of the woodwork and start filing lawsuits. So you want to make sure that, to the extent that there's substantial liability here for workplace injury, for negligence in terms of, supervising your employees and how they interact with customers in this environment, that you've done what you need to do to at least show that you've done your due diligence. God forbid you're ever in front of a jury on something like this, you can demonstrate that, hey, you did the best that you could do under the circumstances, and that's really, you can only do the best you can do. So with that said, I mean, some of the things that we thought of, as far as how to get Executive Order 122 to serve as a guide, staggering pickup times at the dealership. There's this 50% occupancy requirement for the building, and I think ultimately, we're talking about outdoor pickups, but I think it still applies because the more people outside that you need to deal with, the more people inside. And I think ultimately that 50% requirement should extend to the whole dealership, inside and out for purposes of online pickups. I would stagger it. I wouldn't have multiple pickups at one time. To the extent that you're dealing with that kind of demand, which would surprise me, you got to do what you have to do. But if you have the ability to stagger it where there's not multiple people in a pickup lane or a curbside pickup area at one time, that's probably the best case scenario as far as avoiding potential issues. The executive order also suggests establishing special pickup times for high-risk individuals. That definition is defined by the CDC. We're talking about the elderly, people who indicate they have pre-existing health conditions, diabetes, heart disease, etc. I mean, you want to create an environment that accommodates those folks. It's suggested in the order, but it's just good business. Also there's a recommendation about setting up physical barriers and ensuring 6 feet of social distance. To the extent that you're going to need people to sign documents, power of attorneys for title and registration, odometer statements, sales or lease agreements, financing agreements on site for people who don't have the internet and do the deal over the phone. You need to create an environment where there's physical barriers that ensure that 6 feet of distance is maintained. It needs to be taken seriously, and those environments need to make sense to both the employees and the customers. Signage, and we'll get into that in the next page. It's all got to be there so everybody knows what the deal is, and they're not drifting into a 6-foot radius of another person and potentially creating an opportunity for transmission of the virus. On that point, as far as those areas are concerned, desks, etc., you got to provide ample time for employees to disinfect those areas and wash their hands between deliveries. I mean, that's the order has a lot of requirements regarding sanitizing, disinfecting areas, giving employees the opportunity to wash their hands, providing the sanitizer. And I didn't get into everything. Like I said, this list is in no way meant to be exhaustive. I'm just trying to give you ideas on how that order can be used to design a plan with your attorney to ensure that everybody stays safe. Engaging e-contracting whenever possible. That's the last bullet point on the slide. The executive order suggests that should be the preferred method of contracting. Look, not everybody has a computer, not everybody can do it. But if somebody has a computer, I mean, that should be really what you're striving for. And we'll get into electronic contracting later on, but Brad mentioned it before. Get a good vendor who can make the process easy for both you and your customers. I think the customers, most people on the internet these days, they prefer that. They prefer to do it because it's just less interactions, increased safety for them, increased safety for your employees. Everybody wins. And we'll get more into e-contracting platforms and the law on it later on. And as I mentioned before, I'm going to continue to kind of go through a list of items on Executive Order 122. Demarcate areas in the service lane or curbside pickup area where the customer can go, where they can't go. Those things you have at the airport, check-in line, keeping people apart. However you do that, design it in a way where you're meeting the requirements of this order. Signage, again, very helpful. For wet signatures, I mean, I know this is not good customer relations in normal times, but you may want to encourage the customer to bring their own pen if they have to do wet signatures, or if you're going to provide a pen, let them keep it. If you can do a pen, it has to be sanitized. You got to make sure whoever's giving it is wearing gloves, etc. But I mean, that's why it may be easier to just have them bring their own pens. sanitize the inside of a vehicle and the keys before delivering it. You know, if somebody drives it up, do you want to have a spray and a rag and somebody with a mask and gloves just wiping down the areas they touch before they get out? I think that's not only a good safety measure, but it's good customer relations. The customer's going to realize, okay, they're taking this stuff seriously, and they're not going to be inclined to think it was you if they get sick that caused it, and that you're the pocket they're going to raid. Gloves and face masks for all employees and customers. There are some limitations in the executive order regarding face masks for people with medical conditions. For someone who gives no medical reason, you don't have to serve them. But if someone states that they have a medical reason for not wearing a mask, you can't ask for documentation. So you're kind of stuck dealing with somebody without a mask. It is what it is. I would refer to the order with your attorneys in determining how you're going to design your responses to customers who present those types of confrontations to your salespeople, and make sure you have a nice, well choreographed script for dealing with it. And then as far as delivery to a customer's home, all the same stuff applies. You got to come up with policies that meet the letter and spirit of Executive Order 122. 6 feet of social distance, wearing gloves, you know, you step back, the person steps forward. You know, the same type of attention to detail and design, and you know, the need to memorialize the policy is there for remote offsite delivery. It applies just the same as for curbside or service lane pickup. Before I move on, Perry, do you have anything to add, or does anyone else have anything to add? Anyone who's familiar with this executive order, or for Brad or Mike, the CDC and OSHA guidelines, which the order I think attempts to restate and summarize. Anybody have anything that they think is relevant here?
Anthony, I mean, I think more is better here. Obviously, you know, you've got to take these seriously, and the more you do, the more protections you put in place, the better you're going to be. Which is, you know, these are pretty detailed, and I have a lot of dealer clients that are really, really taking this seriously and going out of their way with protective shields and masks and signage everywhere. You know, you just have to really, really make sure you're paying attention to these things.
And this is Jim. You know, I should note that we have furnished the governor's office with a detailed set of protocols, safety protocols, that dealers would be willing to abide by if the governor were to permit by appointment sales in the showroom. And I think that while that's still under consideration in the governor's office, you know, that detailed list of safety protocols was really kind of a collection of all of the best practices that we've seen out there. And you know, that's something that we could share at some point in time. But again, the governor's office has been you know, short on detail, and sometimes, particularly with this administration, I wonder if we're better asking for forgiveness than permission. But we do have a set of guidelines that we've gleaned from the CDC and OSHA requirements that we've incorporated into a protocol, and we'd be happy to share that with the dealers, recognizing that it is not a guideline that's been embraced by the administration. It doesn't offer you any protection, but it does offer you some, I guess, better understanding of what best practices look like.
Yeah, I mean, Executive Order 122, I think, is really the best thing you have as far as dealing with you know, the state administrative enforcement authorities, as far as dealing with state level, you know, negligence claims. You know, obviously, OSHA is its own animal and it has its own set of regulations that you got to follow. But you know, the executive order and the OSHA guidance really mirror one another as far as, you know, what they're requiring. The OSHA stuff just gets more specific on the employee side. And I encourage, we're not going to get into that because we could do an entire seminar on that alone, but really encourage all dealers who are on the call to just read and reread the OSHA guidance to make sure that you understand those obligations as well. This is really customer facing, but the Executive Order 122 does have a lot about employee safety as well. On that note, I think we're going to move on unless Perry, anybody else has anything else to add?
No, that's thoroughly, it's read the order and try to comply the best you can. Very simple, more is better. Exactly.
Okay. Next order that just was released on the 27th of April is Administrative Order 2020-10. And I think this the first, Jim had just mentioned a white paper that we had submitted to the administration trying to get the showrooms reopened on an appointment basis. I think this is the first step in that direction. I think the administration recognized that, a lot of people are not going to be inclined to drop, new vehicle prices these days are astronomical. They're not going to be inclined to drop 35 or 40 grand on a Honda Accord unless they can actually drive the thing. So, I think they recognize that, and or any car for that matter. I mean, they recognize that, and they allowed test drives, but under very limited, controlled circumstances. And this is the only language that they provided. It's not like like I said earlier in the presentation. Typically, when regulations or laws are changed, there's a lot of lead up time for us to discuss what we think the issues are with the people writing the laws, and to come up with a game plan for how we're going to comply with them. We usually get 90 to 180 days before a law takes effect. This just popped up, on April 27th, and we're still kind of wrapping our heads around it. But if you read it, it allows you to do, and I'm going to parse the language in the next slide, but it's so short I might as well just read it. So I'm going to paraphrase. Customers who have ordered or purchased, now that's past tense, online or by phone, to drive the vehicle at the time of pickup or prior to delivery, so that you can do test drives under those circumstances. Under these conditions, you have to comply with Executive Order 122. Which is all the stuff I just went through above, and the order that Perry was referring to. All those social distancing practices have to be followed. The 6 feet of distance, signage, disinfecting common areas, all that stuff applies to how you conduct your test drives. So, the remote sales pickup process, all that stuff's going to apply to test drives. They have to drive the vehicle alone, and then if they don't take the vehicle, you have to sanitize it after the test drive if they don't purchase it. So I paraphrase, I didn't want to just read, everybody can read. So what does that mean? Then I'm going to get to the next slide. So as we said earlier, showrooms are still closed to the public. Test drives are really only for online sales and remote sales. Customers got to drive the vehicle alone. So that begs the question, is your insurance carrier aware that you're going to do this, and are they okay with it? They may not be. And then the other big question is, can you effectively guard against theft? Now, we have a working relationship with the New Jersey State Police Auto Theft and Fraud Task Force, and the point person there who we talk to regularly has told us that auto theft and fraud is just out of control right now since the online sales thing has started. They're seeing a ton of it. So, if I was a car thief, being a former prosecutor, and I know how the criminal mind works, this is easy. You give a bogus driver's license, you go up, and this is in their mind, and off you go. You drive the car to a container in Newark, and off it goes to South America or Africa or Eastern Europe, and you get your payday. I mean, thinking about that, Brad went into the red flags rule earlier. You really got to make sure that you have a process in place that if you're going to let somebody test drive a vehicle alone, that they're not going to just drive off with it. Are you going to have it, if you're going to do test drives, do you have a way of tracking the vehicle, or do you have a way of making sure the person doesn't take off? This just came out 3 days ago. I haven't had a lot of time to think about it, quite frankly, as far as all the methods you can use. There must be vendors out there who can assist with this sort of security issue. That's what I would recommend, talking to your attorney, talking to your vendors, and seeing if they have any devices or protocol. You just got to be careful when you're tracking somebody in general, and your attorneys can give you advice on the best way to do it. The other point here I want to make is the customer must have purchased the vehicle online or by phone before taking the test drive, with the test drive taking place at pickup or before delivery. I think the takeaway from that is the test drive's got to occur at the dealership. It's got to originate at the dealership, because it says before delivery. I don't think a test drive can occur at the customer's home. That would be at delivery, not before delivery. Again, we haven't had a lot of time to parse this, but that's, my take on it. Reasonable minds may differ in their interpretation. I tend to be conservative in the context of a viral pandemic in how I interpret this stuff. Perry, if you have any thoughts, or anybody else has any thoughts on this, feel free to chime in. But I think, if you look at pre-existing motor vehicle regulations, test drives had to occur at the licensed location. Administrative Order 2020-6 and 2020-10 do modify those pre-existing regulations, but in the absence of any clarity, I kind of pivot back to those as my guide. So if anyone has anything to add on that, but I think that's the safe approach. If test drives really need to occur, at the dealership, at the curbside pickup from the service lane, pursuant to this order.
I think.
Go
ahead. Go ahead, Perry. Sorry.
This is Brad. I heard a recommendation here that I thought made sense, at least on new cars, to use a loaner. The same loaner for the test drives, rather than allowing test drives in each individual vehicle that's about to be purchased. Made sense to me from a disinfecting and tracking perspective. Agreed,
100%.
The other thing I would mention, as a practical matter, is that typically people use test drives as a sales tool, but this is sort of the opposite. This is supposed to be after you've already made the sale, right. And it's really just if the customer is feeling sort of unsure and wants to make sure that the vehicle is what he or she ordered. It's not necessarily something a dealer is going to necessarily want to offer unless it's asked for. It's not you can't have a salesperson in the car, you can't demo the car. Like this is after everything's supposed to be already done. So it's not the word point. Test drive doesn't really quite do it justice, because it's not what we normally think about when it comes to test drives.
And Mike, this is Perry. I was thinking that too. It really is not a test drive. It's really just a confirmation after you've essentially agreed to buy the car.
Yep. And then the question comes up, well, if the person doesn't like it after they've test driven it, quote unquote, can they get out of the deal? Legally, maybe not, but I don't think I'd hold somebody to it. I think you're like any retail automotive sales or lease transaction, the customer's in control when you consider New Jersey law.
I would hope no dealer would under those circumstances refuse that request. That would probably not be a good idea.
Exactly. So, Mike, I think it's an excellent point. I mean, test drive's kind of a misnomer here. It's really more, to give consumers an opportunity, before they put themselves on the hook for a substantial financial obligation, to just, truly understand what they've agreed to and what they're purchasing. It's not in the traditional sense, a marketing and sales tool, because you're not even in the car with them. So you're right.
And with respect to the location at which the test drive takes place, let's not forget the practical considerations that, if you're offering a test drive at somebody's home, the additional security and identity issues that come up, that vehicle could easily be on a container ship to Eastern Europe before you knew it. And also your insurance carrier may have something to say about whether or not any losses that you might sustain after offering a test drive at somebody's home would be covered or not. So there are some other practical considerations to keep in mind.
It's tricky for sure. The last point, the order requires you to clean and disinfect the car after each test drive. The customer does not purchase the vehicle. One of the things that I was thinking of is, can you make the customers who test drive wear a face mask? That would at least reduce the likelihood of contamination, since it's a respiratory virus. again, as I said earlier, Executive Order 122 prohibits you from forcing a customer with a medical condition to wear it. If you were to deny somebody who refused to wear it at a test drive, you may end up with some legal issues as a result. I would be very careful in taking those types of positions. If somebody has a medical condition, they refuse to tell you what it is, and the executive order allows them to refuse to tell you what it is because they don't have to give documentation. They don't want to wear a mask. You say, sorry, no test drive. Could they claim that you discriminated against them because of a medical condition? It may not be a rabbit hole you want to go down. Something to think about. All right, if no other additions to that, I'm going to move to the next slide. This is tricky. I mean, I've alluded to this throughout. The dealer licensing regulations, we started with this, the first slide, the background slide, requires sales activity to occur at a dealer's licensed location. Now, Administrative Order, 2020-6, which allowed online sales, and then, this test drive Administrative Order doesn't really, as we just said, doesn't really seem to suggest that it can occur off-site. But as far as the sales activity, what we're really talking about is execution of documents, agreements, disclosures, final negotiations, reaching a final price. That's the typical requirement by the licensing regulations. It has to occur at the licensed location. Now, if you go to Executive Order 107, which closed all non-essential retail, it closed showrooms to the public, but it didn't close the back offices. It didn't close the BDCs. Likewise, if you look at Administrative Order 2020-6, which allowed online or remote sales, it's very unclear on where the salesperson needs to be. Can they be at their home working through a remote portal, or do they have to be at the dealership? The way I look at it is, as I said before, in the absence of any explicit guidance in the administrative or executive orders, I pivot back to the pre-existing law, the current law. And I think as a result, if you're going to be doing remote negotiations over the phone or via email or e-contracting, it really should be conducted and administered by somebody who's working at the dealer's licensed location. We alluded to this with the cooling off rule, or the FTC's cooling off rule. If you start doing coming to agreements and upselling off-site, you may end up inadvertently creating a right to rescind the contract for the consumer. You're not going to want that. So, generally speaking, I think we recommend no upselling during remote deliveries. Sales got to be done. Deals got to be done. And we said this earlier. And salespeople really, they probably shouldn't be the ones doing it. You should have a delivery person who's doing it. It's a ministerial task. They're taking the car and the keys and some powers of attorney and a odometer statement with sign here tabs on it. They're able to answer questions related to that if they have to, and or they're taking the documents that if the person doesn't have the internet, did a remote transaction over the phone, the sales documents with sign here little tabs on it, and they know how to do it in a way that ensures social distance and is safe. You shouldn't have the salesperson doing it because it create the inference. Somebody wants to make a claim that there was upselling on site, aftermarket products, etc. And then an off-site sale occurred, and as a result, the right of rescission is triggered under federal law. That being said, I understand that they may want salespeople to do it because they can answer a lot of the continued questions. But best practice is probably not to do that. If they have questions, they can call the salesperson on the phone. But upselling off-site is a big no-no. Not only because of the cooling off rule, but if you look at pre-existing regs and you read them alongside the administrative order allowing online sales, I think the conservative approach is to have the remote negotiations, final negotiations, and any type of e-contracting and just the agreement itself, the substance of the agreement, agreed to by somebody who's at the dealership's licensed location in the back office of the showroom. All right. Perry, anything to add on that from a state law perspective? Did I cover everything?
Yeah, the interest, this may be a side topic, but I don't know if Jim is still online, but I will just point out that I've had several dealers contact me and say, as a result of this sort of delving into online sales, should we be concerned about future efforts of organizations like Carvana, et cetera, having an argument in New Jersey that, are we opening up the door for them? I don't know if you guys have
Absolutely
heard that, thought about that, Jim.
Yeah,
I don't know if you're
Perry. Yeah, Perry, I'm on, and we have been talking about this internally and with the Motor Vehicle Commission since day one. Anthony and I are working on a detailed proposal to the Division of Motor Vehicles, and as recently as day before yesterday, I had a conference with the Motor Vehicle Commission folks who are anxious to see our recommendations about how to move forward. And now this is very tricky, because I think in the post-COVID world, the online sales developments are going to continue, and dealers are going to have to meet customers where customers want to be met in terms of online sales. The Motor Vehicle Commission shares our concern about not allowing online sales to become, the wild, wild west, Ukrainian scam artists selling cars online in New Jersey. And so, tightening and aligning the licensing requirements with relaxed online sales is, I think, the way we're going to try to proceed with this. At the same time, we have serious concerns, NJ Carr, that are not necessarily shared by the regulators, that opening up the online sales world provides opportunities for encroachment on the franchise protections. And so we're trying to thread two very difficult needles here. The regulatory requirements that the MVC wants to see remain in place, so we know who is selling and that they have physical licensed locations in New Jersey from which they're selling, but permitted to sell online. And then to protect the franchise rights of dealers so that automakers and other disruptors won't be able to take advantage of these rules to sell new vehicles in the New Jersey market online in a way that they wouldn't have been allowed to do so before. So we're on it, but it's not an easy set of traps to run.
I'm sure, and I didn't mean to divert or get sidetracked here, but I have had some questions about it, and I'm glad to hear you guys are on it. So thank you.
Yep, Perry, we are on top of it. It's a very, as Jim demonstrated in his explanation, very tricky balancing act that we're trying to achieve. But I think the consumer preference after this is unquestionably going to be towards increased convenience with online transactions. And if we're
definitely going to be a different world in many ways.
If we're not able to meet those demands, the people who are in position to do so are going to eat our lunch. So we need to figure out a way to maintain the franchise protections, but at the same time, be able to level the playing field and compete. All right, next slide. So that kind of segues into, and I think we've touched on these issues. This is just a state law that governs electronic contracting. It's called the New Jersey Uniform Electronic Transactions Act. The takeaway from this is that you can't deny enforceability of a contract just because it was memorialized electronically. The key is that you need to be able to demonstrate the customer understood the electronic contracting process, that they manifested assent to the whole process. So, really you want to make it crystal clear that the customer is okay with doing all of this stuff electronically. As we mentioned before, identity confirmation is huge, not only for red flags purposes, but also is the person who signed the contract, the person who's listed on the contract. If it wasn't, then obviously it's not going to be enforceable. You need to be able to confirm that, not only for red flags purposes, but also for enforceability. Document retention laws for electronic documents and ensuring security of those documents. You need to make sure these documents are retained for purposes of complying with state and federal law, and also if you ever have to defend against litigation, you want to make sure you can find this stuff so you can know what happened in preparing your defense. You got to maintain security, which we said before with safeguards rule. Obviously, you don't want these documents to be tampered with if they're not secure. It can create all sorts of problems for enforceability. And we've touched on these issues. I'm just really hooking it into the idea of having an agreement that's memorialized and retained so you have proof. The key issue, Perry and I were talking about this yesterday, with a lot of this e-contracting is, 85% of deals are financed. There's some type of third-party funding source involved in the deal. You got to make sure they're okay with it. You could send them an e-contract. They could say, what the hell is this? And then obviously you got a problem. You're not going to be able to fund the deal. So, really, Brad mentioned this earlier, and it's really important. You got to talk to your lenders. You got to figure out, what they want, what they're going to accept assignment of, and then you got to work with a vendor who's going to be able to give them what they want. And I know, Brad, you had mentioned this in the NADA's webinars, but I really can't stress it enough. The vendors, you got to get somebody who's reputable, and you got to have your private attorney vet their process. They may swear up and down that their process is airtight, and it could be garbage. You have no way of knowing unless you know the law that governs what they're doing. And, let's face it, it's a complicated area of law, and most people don't know it off the top of their heads. The attorneys, the good attorneys out there like Mike and Perry will be able to help you figure out, okay, is this vendor selling me snake oil, or is this legit? And is this going to give me what I need to to meet all these requirements that I just went through, and also to satisfy the funding sources so I can get these deals funded. So that's very important. I don't know if anybody has anything to add on that.
Well, Anthony, I was going to say, you and I talked about this yesterday. I'm sorry, I hope I didn't speak over. There are hundreds and hundreds and hundreds of dealer retail finance agreements with lenders. I've looked at thousands of them probably over the last 25 years, and they have, many of them have 20, 30, representations and warranties. And I have seen ones that say one of the representations and warranties would be something like, dealer warrants and represents that the negotiation and confirmation of the sale occurred at the dealership's premises. Right. Obviously, if you have that in your dealer agreement, that's a problem that needs to be clarified, amended with your lenders. So your point is, you need to know what your dealer agreements say, your finance agreements say. I know that, for example, Toyota, has already sent out, PFS has sent out memos to dealers saying, hey, this is it's acceptable, we're on board with this. But that's good, and I assume other captive finance companies have done the same. But related to that, just keep in mind that, and we've touched on this previously. I think Brad and I think Mike mentioned about identity issues. You are on the hook for identity situations. One of the other representations is that you are representing that the person signing this contract is the person they purport to be, et cetera, et cetera. So even if your lender allows it, you go through the process. If there is an issue about the identity, if something comes up, you are on the hook theoretically for this. So just because it's permitted doesn't mean there couldn't be an issue about identity at some point. Hopefully, like many things in life, there is a little bit of risk. It's not a great risk, but it doesn't mean that it couldn't come up as an issue down the road.
Absolutely. We said this at the outset, and I'll say it again now. This stuff is weeks old. Prior to March 21st, we weren't thinking about this stuff at all. It was, we were thinking about it in terms of what's the future going to look like? How are we going to, deal with this over time? But it wasn't immediate like it is now. And I think as a result, it's everybody's scrambling to come up with a game plan for dealing with this in real time. It's extremely difficult to do something like this fast because there's so many moving parts to it, as hopefully this webinar has demonstrated. And it really, it requires you to really sit down and think through this stuff deeply and do it with the assistance of counsels. And we will do what we can to continue to release relevant information and do webinars to frame the issues and to provide the relevant information. But as far as coming up with a plan for this, there's good attorneys out there who can assist you with putting a plan together. And making sure that you guard against a lot of these issues. It's just there's so many moving parts, especially doing it on on a 4-week time frame. Trying to get up and running is very challenging. Okay, as far as remaining wet signatures, as far as I know and what I've been told, the Motor Vehicle Commission is still requiring wet signatures on documents submitted to it for purposes of titling and registration. So we're talking about POAs, odometer disclosure statements. Arguably they should be taking electronic signatures under the New Jersey Electronic Transactions Act, Uniform Electronic Transactions Act. There's the requirement to provide those types of signatures with the same level of enforceability, but they still want wet signatures. Where we live in their world until we can persuade them otherwise. It's not entirely clear on how dealers can obtain those signatures in a contactless manner as required in the administrative order. As I mentioned above, Executive Order 122 is the best that you've got. You follow those social distancing guidelines in paragraph 1 of that order, and that's really the best you can do. They want it contactless, but if they still want wet signatures on Motor Vehicle Commission documents, it's kind of a catch-22. So there's going to be some in-person interaction. To the extent that there is, Executive Order 122 is your benchmark. And again, you seek the advice of counsel, formulate written policies, and then train the employees accordingly so you can show you did your due diligence. Last but not least, before we go to questions, this is really important. The New Jersey is some of the most stringent advertising regulations in the country. All of those regulations still apply. Mike alluded to this earlier on. This isn't the Wild West. We got a very kind of narrow grant of authority for online sales. All the pre-existing laws that govern in-person sales still apply. That includes the advertising rules. You're going to be very careful about trying to use this as a marketing opportunity. Making any type of guarantees that your vehicles are safer than somebody else's. Or selling certain products. I've seen them out there now, purporting to guard against contamination. You got to be very careful with that stuff. You don't want to be in a position where you end up with a products liability claim or a consumer fraud claim related to this pandemic, and the appearance that you try to use it as to gain market advantage. The jury would just rake you over the coals for it. They'll be settling very early on at the recommendation of any competent attorney. Again, we recommend referencing the pandemic in any type of promotions or advertising statements. Not only is it pretty obviously in bad taste, but the regulators they'll be all over it. They'll see it. They're not going to like it. They'll find a reason why it's wrong, and they'll probably whack you for it. The last issue.
Yeah, Anthony. I'm sorry. Anthony, what I wanted to mention there is that my concern in this area that comes immediately to attention is delivery fees for as a result of online transactions and deliveries. I've seen some dealers soliciting online sales and indicating free delivery within X miles. So I presume if it's beyond a certain mileage, those dealers are charging a fee. I don't know how everyone is handling it, but obviously, to the extent there is advertising associated with online fees, and in any fashion references vehicle pricing, as you know, in New Jersey advertising regulations specify that when there's an advertised price, it has to include all costs to be paid by the consumer except tax and motor vehicle fees. So if there is going to be a fee that dealers are going to be charging, that has to be included in any advertised price. Otherwise it's a violation of the advertising regulations. So
I agree. I agree to the extent that if it's an across-the-board fee where everybody's being charged it, like a dock fee, then yes. I think if the dealer is doing courtesy delivery within 30 miles, and then anything above that is going to be a flat fee, then I think that's something that obviously you're not going to be able to determine whether the purchaser is going to pay. I think you have to disclose it. I don't know if the latter scenario has to be included in the advertised price, but if it's everybody who does curbside pickup or delivery has to pay, an extra $30, then I think, yeah, you have to include it. It gets real tricky though if some purchasers do and some purchasers don't, depending on the circumstances. I mean, I leave that to you.
Yeah.
Sort that out on a case-by-case basis with your clients. But I think the issue is there. It's something to think about.
Yeah, definitely something you have to consider.
Yeah. I would also just caution against, in this time and this crisis, of using a COVID-based delivery fee of anything more than something that's incredibly reasonable and just to defray costs. This is not. Do not use it as a profit center, because my God, it's not going to look good it's not going to work out.
Yeah, Mike, your point is well taken. I think, and something we've I tried to stress, and I thank you for raising it at the outset. This, we're everybody on this call is listening. We're sophisticated business people looking for opportunities. This whole crisis, as the title of this first slide on this presentation, opportunity, to the extent that it's there, has to be very carefully weighed against liability in this environment. And, to the extent that there's optics issues, if it even feels slightly funny, I mean, go with your gut. I just think that it's just that I wouldn't want to be representing a client in front of a jury in a situation where there was any inclination that the dealer was trying to use this situation to their advantage. It would not turn out well.
Well,
yeah,
and
not
also
only
remember,
that, yeah, go ahead, Jimmy.
Just remember, Consumer Affairs has the authority, and the Attorney General has made it clear that they will use the authority to impose enhanced penalties for any price gouging during an emergency. This came up during Superstorm Sandy, and the courtrooms are littered with the carcasses of businesses that tried to take advantage of people during Superstorm Sandy. And I think the Attorney General has signaled that the same thing is going to happen here. So if a delivery fee is unreasonable, I think that could fit within the price gouging definition, and would subject you to not only the underlying penalties, but enhanced penalties as well.
Yeah, and just to note,
and in addition to that, the horrible public relations fallout from something like that would probably be worse than the penalties that would be associated from a consumer affairs matter.
Absolutely, and one thing I should have noted throughout this presentation is, the Executive Order 107, which really is incorporated in everything we talked about. The one of the penalties for violating it is disorderly persons offense, which is up to 6 months in jail and $1,000 fine. Now, they're going to reserve that for especially egregious situations, but if they're seeing a pattern of violations across a particular industry, I wouldn't be surprised if they use that to make the point. So, this, there's that undercurrent to all of this stuff. You just can't forget what we're in. We're in a pandemic, and the regulators are not going to take kindly to people who look at it as an opportunity to make money. That's what we're in business to do. This is, as Jim always says, this is business, not religion. But as Perry said, the PR nightmare will outweigh any inch of an advantage that that kind of fee strategy will obtain. I think that's all we got. Let's turn to questions, unless anyone has anything to add.
Jim and Anthony, I actually been getting texts from some dealer clients while I'm on this webinar, and yeah, I love clients, but the overriding question that I keep seeing is about wet signatures, and I guess my just gut thought is here is I don't quite understand why MVC would require wet signatures unless I'm missing something here. Isn't the governor actually encouraging, total disassociation away from customers and online sales? Why would if the MVC is indeed still requiring wet signatures, doesn't that seem kind of at odds with the whole concept of this process and what the governor's trying to put in place? And is there any way to get the MVC to if they are, because it seems like there's some confusion on that, if they are requiring wet signatures, to see if they would during this period relax that rule?
Let me take a crack at this, because I think we've got to acknowledge the fact that many dealers aren't set up to take anything other than wet signatures. And as I said earlier, it's often better to ask for forgiveness than permission with these people. If we say we want them to accept wet signatures, and they turn around and say, okay, fine, we want them to accept electronic signatures, and they turn around and say, okay, fine, in accordance with the governor's executive order, we will only accept electronic signatures, then many of our dealers are going to be in a tough spot.
I understand.
So I think the current situation, we haven't figured out how to 3D print a car in somebody's driveway yet. So you're going to have to make delivery of the vehicle. And so long as we can get the wet signatures at delivery, I think this is one of those don't ask, don't tell moments.
Yeah, it's tricky. It's a catch-22, Perry. And yes, it doesn't make any sense. But as Jim said, we got to be really careful about what we ask for, especially in this context. Everything's been released so fast without a lot of deliberation. We'll provide a white paper, and then we'll get 3 lines, and it's, well, what does this mean? And we're not going to get what it means. So the last thing we want is some kind of incomprehensible gobbledygook from the NBC, and then it throws everybody's a wrench in everybody's gears, and then we can't do anything.
We as part of our conversations that we're having right now with NBC and the action items, after action items for us to address both regulatory and legislative, will be tearing down some of these archaic rules. MVC rules specifically prohibit online sales. MVC rules specifically prohibit dealers delivering vehicles away from the dealership. All of that stuff is going to have to change. We want to manage that change in a way that doesn't undermine the MVC's ability to keep fly-by-nighters out of the business, and also that doesn't undermine the value of the franchise system.
Okay, Jim, just to clarify, courtesy delivery has always been permissible under the regs. It just, the sale has to be complete. You can't be driving to somebody's house and with paperwork to sign
right.
under the pre-existing regime. If the paperwork's signed, everything's done, then you can do a courtesy delivery. What you can't do is bring the car and the paperwork to somebody's house.
That's right.
Unsigned paperwork. Anybody else have anything? Yeah, right. Anybody else have anything to add before we go to questions? Which is probably going to be, I'm sure there's a lot of them, Brian.
Actually, there aren't right now. But the first one I'm going to give is actually what Jim mentioned it early in the program, to allow people some time to submit questions about the webinar itself. Jim, someone had a question about the NJ Carr's requested approval for opening of scheduled appointments to showrooms. Is there any update to that, a time frame, any more information you can give them about that?
No, as I said earlier, we had sent in early last week a detailed proposal for opening dealership showrooms by appointment only. as part of that proposal, we articulated one of the major obstacles to selling vehicles online is the lack of access to test drives. Their response late last week was to say, early this week was to say, okay, we'll give you test drives under limited circumstances. So, I mean, I would say that was some incremental progress. We continue to press hard on the opening the showroom. Over the last couple of days, the Senate leadership, the state Senate leadership, has formalized a request to the governor's office to allow dealership sales to restart. We're pushing every button and pressing as hard as we can. Could happen this afternoon, could happen Memorial Day. I honestly can't tell you. All I know is, we're in touch with the governor's office. We've made a thoughtful and very detailed presentation that shows them this can and should be done successfully and safely. Since they make more money on the sale of a new car, the state of New Jersey makes more money on the sale of a new car than a car dealer does, they should be more anxious even than we are to see vehicle sales resume.
One of the arguments we made was that, Executive Order 122 applies to service. And really, what's the distinction between an appointment sale in accordance with all of the social distancing guidelines in Executive Order 122 and allowing the service lane to remain open for people, who want to buy a car but are hesitant because they don't have the ability to see it. And as Jim said, the test drive seems to be the first step in that direction.
And we've also made the argument that the typical dealership showroom isn't like any other retail environment. The dealership showrooms, a minimum 7,500 square feet typically in the state of New Jersey. Some of them are, as you're all too painfully aware, palaces. Social distancing is not something that's that difficult to do in an industry where the typical sale involves 2.3 visits to a dealership, including the delivery visit. So, most dealers are only seeing a few hundred people a week coming through their dealerships. If they were to schedule those by appointment, the ability to socially distance is considerably greater than that which you see at a Home Depot or the local liquor store.
A dealer did actually, as you guys were answering that, someone just pointed out, if Homeland Security is deemed car sales essential business, shouldn't that impact what the governor does in allowing showrooms to open similar to service?
No, that is
keep in mind that that's a federal designation. The governors have the authority to make their own decisions to protect the health, welfare, safety of their residents. So the Homeland Security designation is guidance only, and read the guidance. It essentially says dealers are essential services when they're repairing vehicles and selling to individuals who are engaged in essential services. So it's not as broad a designation as you might think. I mean, look, it's helpful. I think it's instructive. I wish the governor would take the same position as the president did, but he's under no obligation to do so.
Okay. We actually do have 3 questions here related to the webinar. In a contactless delivery with a previous phone-based F&I presentation, should the dealer still keep a copy of a menu and signed accept decline form for any ancillary products?
The dealer should do all the paperwork that was completed, that was previously completed in an in-person sale, should be completed in an online or remote sale. The question is, how do you do it? But the paperwork requirements will be identical.
Well, and this is Brad. It's a great question, and it's one of the issues. I'll just tell you, while it's easy to sort of say, hey, look, you should look into e-contracting. As I'm sure I'm telling dealers know this very well, it's not that simple in every case. And even the best e-contracting platforms, in many cases, will just be the contract, just the retail installment sales contract. Right. So all your voluntary protection products, all of your, whether it's your used car buyer's guide, whether it's your PO, there's all the stuff that you get signed. You're going to have to come up with a process to get that, while the wet signatures that were listed here today in terms of requirements are requirements, you may have a bunch of other documents that you need to get signed as well at the time of delivery. So I just think it's one of those overarching issues that, I'm sure NJ Carr will give lots of great advice. We've put out lots of guidance. E-contracting is more than just electronic contract. It's process. It's changing. It's doing everything you do in the store, but doing it potentially electronically. And today, you learn a lot of those things you simply can't do electronically. So it's a great question, and I think it just adds to the need to get that in-person delivery process right.
Okay. This next one, I believe you guys kind of addressed this, but they may just be looking for more clarification. If a customer ordered or purchased a vehicle online or on the phone, does the transaction have to be consummated prior to the test drive, or can the test drive occur before the transaction is completed?
The order, which I'll switch back to it on the PowerPoint, because it just makes it easier. But our view of it is, if you read the order specifically says may permit customers that have ordered and/or purchased a vehicle online or by phone. And that's past tense, ordered and purchased, which means it's already occurred. We touched on this. Drive the vehicle at the time of pickup or prior to delivery. So I think the answer is, and we kind of discussed this, it's not as much a sales tool anymore as it is a confirmation. I'm getting what I'm paying for, which leads to the question is it even worth it? But ultimately, I think the answer to that question is the test drive has to occur post-order or purchase, and then obviously, as the order states, at the time of pickup or prior to delivering it to somebody's house, which I think leads to the conclusion that it's got to be done at the dealership.
But the number 3 point would suggest that it can be before purchase, because if the customer chooses not to purchase it, then there's a list of things that must happen after that. The other thing I would note is I'm not sure, based on the wording of this order, that you can test drive a loaner, because the thing you're supposed to test drive is the vehicle they've ordered.
It's
very gray.
Yeah,
it's not entirely clear.
Right, the language, and Mike makes an excellent point. The language at the top suggests one thing. The language at the bottom regarding, if they choose not to or does not purchase, suggests something entirely different. It doesn't make any sense. And unfortunately, this is what we get when you have, these things are just released. Probably, among a zillion other things the governor's office is dealing with right now. We get their best crack at this stuff. Some of it just doesn't make any sense and begs more questions than it answers.
Okay, and then we just have a last question, unless any more pop in here while it's being answered. And this one's actually directed towards Brad, I think, and I know NJ Carr doesn't have this. Does NADA have a list of recommended vendors for remote e-contracting? I know NJ Carr doesn't. They were asking if we did either.
It is a very good question. Stay tuned. I don't know, not yet. We just, when was it, Monday, I did a hour and a half webinar on the types of vendors that you will need to consider as you go through this process, but we did not talk about specific individual ones, but that may be coming soon.
Great. Well, that's it for the questions. So thank you to Brad, Michael, Perry, Jim, Anthony, and thank you to the participants who gave us some good questions there. Does anybody else have anything else to add?
I think that's all we have, unless anyone else has anything else to add. I think that wraps it up.
Thanks, everybody, for coming today.
Thank you all. Much appreciated.
Yeah,
Thanks again.
a recording of this webinar slides will be posted to the NJ Car website later today. And that concludes today's webinar. Thanks a lot. Stay safe.
Thank you.